Good evening, everyone, and welcome. My name is Hunter Boucher, and I am Vice President Operations at Landlord BC. Thank you for joining us for this evening's Landlord BC webinar on the Cowichan decision and what it means for homeowners, rental housing providers, and private property interests in British Columbia. For those that might be newer to Landlord BC, we are BC's rental housing association, supporting rental housing providers across the province through advocacy, education, member resources, and practical guidance on tenancy issues. Our work is focused on helping create a healthy, professional, and sustainable rental housing ecosystem in British Columbia. Before we begin, I want to also mention that for anyone who is not currently a Landlord BC member, we are offering a limited time discount on membership until the end of June. You can use the coupon code JUNE26 when joining to receive a $50 off discount membership. Membership gives you access to our helpline, forums, education, member resources, and ongoing updates on issues affecting rental housing providers across the province. Today we're very pleased to be joined by Michael Drouillard. Michael is a lawyer with deep experience in residential tenancy law, housing policy, and legal issues affecting landlords and property managers in British Columbia. He has worked closely with Landlord BC on a wide range of issues, and many of you will know him from previous webinars, education sessions, and legal updates. Michael is going to be walking us through this decision, including what the court decided, what it did not decide, and some of the key misconceptions that have been circulating publicly. In particular, he will explain the distinction between Aboriginal title, fee simple ownership, government-held land, and private-held property interests, and why this decision is more nuanced than some of the headlines might suggest. With that, I'm very pleased to turn it over to Michael Drouillard.
Thanks a lot, Hunter. Nice to meet all of you. I'm just going to share my slides now. Just give me a moment. And maybe, Hunter, can you confirm you can see my slides? Any issue with them? Do they look like they're appearing?
They do look like they're showing up, yeah.
Okay. All right. So we'll begin. So thanks for that introduction. So those of you who don't know me, I'm also vice chair of the board of directors of Landlord BC. And I'm chair of Landlord BC's legal committee. And I am a practicing lawyer with a practice focused on real estate transactions and disputes. And this does include disputes and transactions involving Aboriginal land interests. I have a disclaimer that, of course, we're just talking generally about the subject matter today. The goal is education, first and foremost. Generally speaking, it's not legal advice for your particular circumstances. And I say this just so that I can have an open discussion about my views on this case law. The other thing I wanted to say is about the scope of today's discussion, because as I say in the slides, Aboriginal relations are very complicated and they are multifaceted. There is a political dimension to them as well. This presentation is not about the politics of Aboriginal law. It's about the legal perspective. And the idea is to talk about this subject in a scientific way, separate from the political element that can sometimes confuse matters. So we're going to just dive right into it. And what I first wanted to talk about was Indigenous land interests and how Indigenous nations can hold land. So first, there are reserve lands. Many of us are familiar with reserves. It's because they've been around for a very long time. They were established under the Indian Act, which is federal legislation. And the idea of reserve land is that this was a setting aside of lands for specific Aboriginal nations for their use. One of the problems with the Indian Act is that it created great restrictions on how Aboriginal nations could develop and use their lands as compared to fee simple ownership. And so more recently, we're seeing the federal government giving Indigenous nations the opportunity to opt out of these very restrictive land management provisions to give them greater control over their own destiny and the management of their lands. So there's reserve lands. There's also lands that are held pursuant to special legislation and to historic or modern treaties. And I'm lumping them together, even though they're conceptually quite different, for the purpose of saying that Both of them have the same effect of giving Indigenous nations a very much greater say and direct control over their lands, how they're used, and how they're developed. One of the features of British Columbia is you'll often hear in land acknowledgements the idea of unceded territory. And that's referring to the fact that much of BC is what's called unceded, meaning that British Columbia and the federal government have asserted dominion over these lands without having reached agreements with local Indigenous people who lived here well before Canada was established. The other ways that Indigenous nations can hold lands is through fee simple interests. So we're seeing more and more Indigenous nations purchase and own fee simple interests outright. They might add it to their reserve or they may not. The point is that an Indigenous nation can hold a fee simple interest in land just like anyone else. Now we're going to talk a lot more about Aboriginal and title and Aboriginal rights, but for now I'm going to say that what Aboriginal title is it's a collective right to land arising from that Aboriginal nation's occupation, use, and control of the land at the time Crown asserted sovereignty in British Columbia. Then there are Aboriginal rights, which are lesser than Aboriginal title, where it may be a situation where an Aboriginal nation can establish that they have certain rights over a tract of land, like hunting or fishing rights, but without establishing full title to those lands. And so we're going to focus a lot today on fee simple title and Aboriginal title. And in terms of fee simple title, many of you have probably heard this term, but what it is exactly is it's the Supreme Court of Canada has called it the most extensive private interest in land available in Canada. It's not absolute, though. It's subject to exceptions like expropriation, but it's pretty well close to the most complete form of ownership that a private person can have of land in Canada. And the way it's issued is it's typically first issued through a crown grant. The concept is that the government grants this land to someone who can then trade and otherwise deal with it. And an interesting thing that a lot of folks don't know is that only about 5% of land in BC is fee simple title. The vast majority of land in BC is either held by the government or it's reserved land. And as we all know, registration of ownership of fee simple title in BC is governed through the Land Title Office and the Land Title Act. So for those of you who own land, more likely than not, it's through fee simple ownership registered in the Land Title Office. Now, Aboriginal title, it's very interesting and it's very much distinct from fee simple title. It's a concept that has been described and defined through leading Supreme Court of Canada cases. Supreme Court of Canada has been careful to say that it's different from fee simple title. It's not the same thing. It's a pre-existing right that predated fee simple title. It's not registered in the Land Title Office because it's not a fee simple interest or an estate in land. And the idea is that it exists because of the Crown's obligation to recognize that it exists, because the Crown has a unique and important relationship to Aboriginal people that individual landowners like me and you don't have. They have this obligation to act in a fiduciary role in the best interests of Aboriginal nations in respect of their Aboriginal title. Some of you may have heard of the Chilcotin decision from 2014. This was a very important decision, which, to put perhaps oversimplified, confirmed that an Aboriginal nation can seek a declaration of Aboriginal title over Crown lands. And so the thing about the Cowichan case, the unique thing about it is that it involved a declaration of Aboriginal title over lands that were held by government agencies, but also private landowners. But it did not create the concept of Aboriginal title. In many respects, as I say in this slide, the Cowichan decision can be seen as an application of Chilcotin. Rather than new law in that perspective. And so what happened in the Cowichan case is the Cowichan Nation sought a declaration of Aboriginal title to their traditional village in Richmond and its surrounding lands and submerged lands. And these lands were owned by three classes of people. It was owned by Canada, the federal government, who owned these fee simple titled lands as a matter of convenience. And what I mean is that Canada didn't have to make the parcels of land it owns directly fee simple titled. It chose to do that for administrative purposes. Then we have the city of Richmond, which held land in this area. And then we have private landowners like me and you holding fee simple estates in this area. And I've reproduced this drawing. It actually comes from the Cowichan decision. Maybe hard to see on your screen, unfortunately, but you might see a area that's highlighted in black with black lining. That is the area where the court declared Aboriginal title. So that included lands owned by the three classes of people I previously mentioned. And uh, establishing Aboriginal title is very difficult. And I think there is a tendency to perhaps oversimplify the matter. I mean, I've seen sometimes media presentations suggesting that all that has to happen is you have to say that my great 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 grandfather lived there and hunted there, therefore the land is mine. And so it's much more complicated than that, because in order to establish Aboriginal title, you have to prove as an Aboriginal nation um, sufficient occupation and exclusive possession. And what I mean by that is the Aboriginal nation has to prove that they had exclusive control of this area as of 1846, the date of assertion of Crown sovereignty in BC, and that it was sufficient occupation. The idea that there has to be evidence that this was controlled by or under the exclusive stewardship of the Aboriginal nation claiming it. Some of you who have seen the Cowichan decision, you might remember that there were other Aboriginal nations opposing the claim of Aboriginal title, because the idea is that only one Aboriginal nation can seek a finding of Aboriginal title over a given area. It can't be shared. And so there were actually Aboriginal nations opposing this claim, saying, "Hey, wait a minute, we have an interest in that land too. The Cowichan Nation cannot say that they have exclusive possession and sufficient occupation at that time." And so this is very difficult to prove. And what happened, and I'm going to go into how it was proven in that case. And by the way, if you hear honking outside, we had a very successful day, Canada against Qatar. So there's very happy folks downtown where I am located. So sorry if you hear that. So the relief sought in the Cowichan case was they sought a declaration that the fee simple titles held by Canada in the city of Richmond were invalid. And you'll note that I didn't say the private landowners. They didn't seek this finding against the private landowners. In fact, they sought nothing against the private landowners except for this declaration that they had Aboriginal title in this area. And so that's very different from what was sought against the government groups, because they weren't seeking anything. And I'm going to talk about this in more detail later on, about how Aboriginal nations are careful not to seek remedies against private landowners. And there's a number of reasons for that. And in this case, the Cowichan Nation had a pretty strong basis to claim Aboriginal title. In my slides, you'll see quotes from the decision. I know, unfortunately, it's small words. I did the best I could. And keep in mind, too, that the Cowichan decision is massive, thousands and thousands of paragraphs, way longer than your typical court decision. Um, it doesn't do the decision justice for me to pick some paragraphs from it. You got to read the whole thing to fully understand it. But I did have referred to some paragraphs that I think illustrate the points I want to make. And so in this case, the problem here was the Cowichan's rights to this lands were egregiously breached because what happened is at the time, Governor James Douglas had implemented a policy that directed that these lands would be set aside for the Cowichan as reserve lands and that they wouldn't be subject to private land ownership. But the problem, and so there's evidence of this, and the court discusses it in the paragraphs I've referred to, that Governor Douglas informed Moody, and you're going to see a few references to Moody. That's Richard Moody, the first Chief Commissioner of Lands and works for the colony of British Columbia. His job was to ensure that reserves were created at the sites of Aboriginal settlements. And so Governor Douglas informed Moody that these lands were to be reserved and not subject to preemption, which was the way that lands would be set aside for private ownership. And the idea was that Governor Douglas intended to preserve sites of Indian villages, including the Cowichan's village, for Indigenous communities. So the law was, under British Columbia's law, these were supposed to be the Cowichan people's lands. And this was consistent with direction from the United Kingdom at the time as well, from Britain, I should say. The idea was that Britain wanted these lands set aside for reserves for Aboriginal people so that they could be settled into their traditional villages. And the judge found that the evidence was sufficient that Governor Douglas intended for these lands to be set aside for the Cowichan people. And it was consistent with the policy of the government at that time. But what happened instead is that his direction wasn't followed. And in fact, other government agents who were supposed to implement Governor Douglas's direction appropriated the land for themselves. And so I refer to a few paragraphs of the decision where the court found that Moody knew about the Cowichan village when he acquired lands in that area. He commissioned a survey of it, and his survey noted the existence of that village. And the court found that he knew about the existence of the Cowichan village. But despite that knowledge, he knowingly acted contrary to Governor Douglas's direction and bought the lands and appropriated them for his own personal use. And the idea is that the Cowichan promptly objected at the time, and they've maintained their objection since then, resulting in this court decision. And so this is a pretty egregious example, and it's not always clear that an Aboriginal nation can establish a title. But in this case, because this was supposed to happen under British Columbia's own laws, it was considered to be a fairly egregious breach. And I've kind of, as I said, I've picked some of the highlights, but there's a lot of history to this, a lot of evidence that's referred to in the Cowichan decision about how the judge was able to reach these conclusions. And so what happened is the court granted the relief sought. There is a finding that the fee simple titles held by Canada were invalid. And the rationale was is that there was an argument made by the government that the fact that the lands had become fee simple titled extinguished that Aboriginal title right. However, the court found that just because Canada chose to have these lands registered as fee simple as a matter of administrative convenience, that didn't change Canada's obligation to the Aboriginal people to act fairly with them. And so it wasn't a defense. And in light of the history of the matter, the judge found that these fee simple titles held by Canada were invalid. Again, Canada is nothing like a private landowner holding title in fee simple. Nothing like this was sought against private landowners in this claimed area. In respect, I'm actually going to move ahead, sorry. In respect of the lands held by Richmond, was in a different category because it's not the federal or provincial government. It's a creature of provincial statute created by the province. And Richmond also tried to advance an argument that they were a bona fide purchaser for value without notice of these Aboriginal title claims. And the court rejected this argument for two reasons. First of all, Richmond acquired these lands through municipal tax sales, where they were essentially forfeited to Richmond without Richmond having to pay market value for them. That's why the judge in this paragraph characterizes them as windfalls. And so the other issue too is Richmond is not like a private landowner like you and me. It's a public body, a creature of statute, and not in the same position as private landowners. So there was a finding that the lands in this area held by Richmond, the fee simple grants were invalid. But again, nothing was sought against private landowners in this area of that nature. A declaration of Aboriginal title was sought, but no remedy was sought against private landowners. So, as I said, in terms of fee simple title held by private landowners, no declaration or other relief of that kind was sought against them. The Cowichan Nation didn't seek to displace private landowners or to invalidate their fee simple interests. And in fact, because no relief was sought against private landowners, it's one of the reasons why private landowners were not even parties to this decision. What happened is it took a very long time for this trial to resolve. And in the late 2010s, there was actually an application made to have private landowners added as defendants, but it was dismissed on the basis that they did not have a sufficient interest in the litigation, which was really seen as being nation to nation, Aboriginal nation against the government, with relief sought against the government. That was the predominant purpose of the litigation. And so what that means is, according to the Cowichan case, just because someone owns fee simple land in an area where Aboriginal title is also claimed, the two coexist. Just because there's fee simple land held by a private landowner doesn't mean that an Aboriginal nation can't seek Aboriginal title with respect to those same lands. And the idea is that when this occurs, the court has said that BC has a duty to negotiate to reconcile their Aboriginal title with the private fee simple interests in a manner that accords with the honor of the Crown. And as the court says, it's an issue for the Crown and not for private landowners to resolve. So the way the court saw this is that this dispute was essentially a dispute between Aboriginal nations and our government. It was not a dispute about private landowners and what they own. The other thing I wanted to talk about briefly is DRIPA, the Declaration on the Rights of Indigenous Peoples, because we've heard a lot about this in the media, and sometimes this legislation is getting connected to the Cowichan decision. There's sometimes suggestions that it enabled the Cowichan decision. It's simply not true. What DRIPA is it's a provincial law that requires legislation created by the province to take all measures necessary, and I took that from the legislation, to ensure that laws created by the province are consistent with the United Nations Declaration on the Rights of Indigenous People. There's criticism about this law that's really outside the scope of this presentation, but the point that I want to make is DRIPA really, it was mentioned briefly in the Cowichan decision, but it really had not much to do with the Cowichan decision or a claim of Aboriginal title. Whether or not DRIPA continues to exist, ceases to exist, Aboriginal title claims have been made well before that legislation, and they will continue to be made, whether or not that legislation exists. The other thing I wanted to talk about more recently is another case has come out of New Brunswick that we're seeing in the media, Irving and Wolastoqey Nation. And hopefully I pronounced that correctly. And it's led to these headlines saying Aboriginal title can't apply to private land. Supreme Court of Canada decides. There's different variations on this. So I want to talk about this because I want to talk about what actually happened here. So the Irving case out of New Brunswick, first of all, it wasn't a trial like the Cowichan case, which took over hundreds of days to resolve. It was a procedural motion. It wasn't a trial, which meant that the only live issue for the New Brunswick Court of Appeal to consider was whether an action for a declaration of Aboriginal title could proceed against lands held privately after the private landowners successfully applied to have themselves removed from the action as defendants on the basis that no relief was sought against them specifically. So like in Cowichan, there was an exception to this, but essentially for the most part, the Aboriginal nation wasn't seeking any relief against private landowners. It wanted a finding of Aboriginal title in the area where these private landowners held land, but not for the purpose of seeking remedies against the private landowners. It was for the purpose of seeking compensation from the Crown. And so it was a procedural motion. And the court in this decision was not considering whether declaration of Aboriginal title could be made over privately owned land as a general proposition. It was more procedural in nature, whether such a declaration could be made without the private landowner appellants being added as parties to the action. And I've reproduced a paragraph from that decision. The court was not deciding this issue like how the media is framing it. It was resolving a procedural issue relating to a declaration of Aboriginal title. Having said that, one of the things that is interesting about this decision as compared to the Cowichan decision is New Brunswick Court of Appeal is saying that even if you just seek a declaration of Aboriginal title over lands that are held by a private landowner, they should be defendants to the action. This is different from how it was in the Cowichan decision, where the court found it was not necessary to have them added as defendants. So as we all know, the Cowichan decision is certainly going to go to appeal. This might be an issue for the Court of Appeal to look at. But the key thing is that in Irving, the court concluded there was no declaration of Aboriginal title that could be made without the private landowners being a party to the action, whether or not remedies or relief were sought against those private landowners. And so the reason why people are saying in the media that the Supreme Court of Canada has decided the issue is it's not correct, but essentially what happened is the nation sought leave to appeal the New Brunswick decision to the Supreme Court of Canada. And so one of the things about the Supreme Court of Canada is they get many requests to have appeals heard, and they hear very few cases based on the number of leave applications they receive. I know I've submitted a few leave applications for my cases, haven't gotten it yet. The stat is something like fewer than 10% of cases submitted for leave are actually heard. And so when the Supreme Court of Canada denies leave to hear an appeal, the Supreme Court of Canada is not making a statement on the issue. It's simply refusing to hear the appeal. And you cannot infer from that that the Supreme Court of Canada has a position on that case. So it's wrong, as I say in the slide, it's wrong to suggest that the Supreme Court of Canada agrees or disagrees with a decision based solely on their decision not to grant leave. My own theory is that Supreme Court of Canada is probably waiting for a decision with a more complete evidentiary record. They want to decide this issue not based on a procedural motion, but on a complete trial record, like how Cowichan was decided over a full trial, as opposed to a mere procedural motion. And so the main point I'm trying to say is when you see statements that the Supreme Court of Canada has decided that Aboriginal title can't apply to privately held land, it's simply not correct. It's just not correct. And so one of the things I wanted to discuss too is what would a claim look like against a private landowner if it was even possible? Because one of the key things I want you to get out of this presentation is that the court cases I've been discussing to date need to be seen more like nation to nation disputes. They're disputes between our government and Aboriginal nations, but not involving private landowners individually. No court has determined whether a claim of Aboriginal title can invalidate a fee simple interest held by a private landowner. And one of the interesting things about Aboriginal title litigation is that Aboriginal nations typically make very clear in their lawsuits that they are not seeking remedies against private landowners. They go to great lengths in their pleadings to carve out this idea and make clear that, look, we're seeking a claim of Aboriginal title, but we're not seeking to do anything in particular with private landowners. Um, there's probably a few reasons for that that are both political in nature and legal. I mean, one thing for sure is that um, private landowners are in a very different position than the government is regarding these matters. Um, the Irving case I've discussed, the court did set out an opinion about why they think that kind of claim would fail. And keep in mind, though, that this position that they put out, it's what lawyers call obiter, meaning that it's commentary from a judge that wasn't necessary to decide the dispute. And so it's not legally binding. And so what the New Brunswick Court of Appeal said in Irving was that if an Aboriginal nation sought to take someone's title, a private landowner's title, that would be totally inconsistent with reconciliation. And the judge says, in my view, a declaration of Aboriginal title over privately owned lands, which by its very nature gives the Aboriginal beneficiary exclusive possession, occupation, and use, would sound the death knell of reconciliation with the interests of non-Aboriginal Canadians. And the idea is that it is not for private landowners who are innocent, who have bought their land without notice of these claims, without even being able to have a say in the matter, to be involved. The court says here, I think it's cut off a little bit, but it says that remedial justice favors compensation from the Crown over possession of private fee simple owners in all cases, although admittedly that's especially the case when the land has passed through numerous innocent hands. And so the idea is that reconciliation isn't one-sided. It's not something that is only resolved in favor of Aboriginal nations and how they want. It's a balancing that includes non-Indigenous Canadians as well. And so this court, at the very least, thinks that it's a non-starter. One of the things that's quite confusing, and which will also be subject to appeal in litigation, is that the New Brunswick Court of Appeal, as opposed to British Columbia's court in Cowichan, drew a distinction between a finding of Aboriginal title versus a declaration of Aboriginal title. The court in Irving says that you could have a finding of Aboriginal title, which would give an Aboriginal nation the basis to seek compensation from the Crown, but you can't go a step further and get a declaration of Aboriginal title. In order for that position to be correct, essentially, in my view, the New Brunswick Court of Appeal is saying that the two interests can't coexist. And so there is going to be litigation and appeals about that issue. But in either case, private landowners are not personally implicated. This is a matter for the government to resolve, not individual private landowners. And one of the reasons I say that is because private landowners, unlike the government, owe no duties or obligations to Aboriginal nations. This is fundamentally unlike the federal and provincial government, who do owe odies to Aboriginal people. These duties, they're sometimes referred to as the honor of the crown. And I've reproduced some paragraphs from the Chilcotin case to explain this. So the court in Chilcotin says Aboriginal title is what it is, the unique product of the historic relationship between the Crown and the Aboriginal group in question. Analogies to other forms of property ownership, for example, fee simple, may help us understand aspects of Aboriginal title, but they cannot dictate precisely what it is or not. As Laforet put it in Delgamuukw, Aboriginal title is not equated with fee simple ownership, nor can it be described with reference to traditional property law concepts. The way I would say that, to put simply, is it's a matter between the Crown and Aboriginal nations, and it doesn't implicate the type of ownership that private landowners have, a fee simple title. And I got an even more wordy slide, apologies. But I wanted to go to the Delgamuukw case as well, which predates Chilcotin, which led to the Chilcotin decision. In this case, the court is saying that the best description of Aboriginal title is that it's a interest in land that is inalienable except to the Crown. In dealing with this interest, the Crown is subject to a fiduciary obligation to treat Aboriginal people fairly. It's a type of obligation that the Crown has to recognize that Aboriginal nations are entitled to. And the court also says in this case, it must be emphasized that fair compensation is not equated with the price of fee simple. They're not the same. You can't equate fee simple title to Aboriginal title. And that compensation must be viewed in terms of the right and in keeping with the honor of the Crown. But honor of the Crown, that's an obligation government has. That is not an obligation that you and I have as private landowners. And so there's a real question of, even with a declaration of Aboriginal title, does that even relate to fee simple title? The two are very different. And one way that I might put it, which perhaps oversimplifies things, but I would say that Aboriginal title is an obligation of the Crown to recognize and deal with. It's nothing to do with private landowners. The other thing that I've thought about too is that if an Aboriginal nation were to make a claim against a private landowner that they want recovery of that land, private landowners are going to have defenses available to them that are not available to the Crown. For example, private landowners would have a defense of bona fide purchaser for value. In other words, equity has long recognized for hundreds and hundreds of years that if you buy property without notice of a claim and you pay market value for it, and if someone makes a claim against your title to that property, you're immune to that claim. That's been the common law for hundreds of years. So that's one defense that might be available to a private landowner that certainly wouldn't be available to the Crown. Unjust enrichment might be available. So if you without knowing that your land might be subject to an Aboriginal title claim, and you've developed it, you've constructed on it, and you've put a lot of value into that land, there's going to be a question of, well, if you lose that land because of an Aboriginal title claim, was that Aboriginal nation unjustly enriched? And that's a whole different thing that's never come up yet, because Aboriginal nations have not sought these kinds of claims against private landowners. But the other issue too is that just because there's a finding of Aboriginal title doesn't mean that there isn't a defense which is known as a justifiable infringement of Aboriginal title. And this speaks to the reconciliation issue that the New Brunswick Court of Appeal discussed in the Irving case. So it may be that, yes, an Aboriginal nation can show that there is a claim of Aboriginal title to a private landowner's property, but to go a step further and say that, well, now we get a say in whether the private landowner has to lose their land or something like that. Well, that will then go to a question is, well, is that justifiable? Because you can have a finding of Aboriginal title, but you can also have a finding that its infringement has been justified. And that this speaks to the issues that the court was mentioning in the Irving case in Obiter. So the key takeaways I want you all to get out of today is that for private landowners like you and me, Aboriginal title does not invalidate fee simple title or vice versa. They exist together. Aboriginal title is a matter for the Crown to resolve and reconcile, not individual private landowners. In the event fee simple title interests were held to be an unjustified infringement on Aboriginal title, it's the government's obligation to reconcile this, not a private landowner. To date, no court has determined the outcome if an Indigenous nation established Aboriginal title and sought to invalidate fee simple title interests held by private landowners. And, you know, with Cowichan having come out, we've heard a lot about uncertainty, and there is undeniably uncertainty that has arisen from this decision. But when we look at what the court is saying in that case, and when we look at the surrounding case law, my position is that this uncertainty, it's arising from marketplace reaction to the decision rather than what the court has actually determined and decided in that case. So hopefully that sheds some light as opposed to confusion, but I was really happy to have the opportunity to do this presentation to just give a pure legal perspective on the issue without the politics of it confusing matters. So thanks a lot for the opportunity. That's my presentation.
Thank you so much. Thank you very much, Michael, for walking us through what clearly is a very complex and important decision with that kind of, fresh level of clarity. There's one point that I want to just kind of cover very quickly, which is how Aboriginal and fee simple title coexist.
Certainly, and I touched on this in the did I cut you off here? Okay, yeah. So I touched on this, and the idea is that I want everyone here to come out of this understanding my position that these coexist because they're conceptually quite different from each other, with the idea being that Aboriginal title for the typical landowner like you and me needs to be seen as separate from our fee simple title and an obligation of the Crown to recognize and deal with as they are required to deal with the idea being that fee simple title is conceptually different from this. It's kind of like if you have a chart and you have the Crown at the top, well, one leg is Aboriginal title and the Crown's obligations, and another leg that is separate from Aboriginal title is fee simple title, which was granted by the Crown. They are two different issues, even though they involve the same land, because they involve very different obligations. And private landowners do not have obligations to Aboriginal nations like what the Crown does.
Okay, well, thank you so much. Just going to close up then. So, yeah, thank you so much for your presentation. Thank you everyone who joined us this evening for your attention on this evolving and new issue. As we've heard today, the Cowichan decision is obviously it's a significant decision, but also highly fact-specific and more nuanced than some of the public commentary might suggest. So, again, thank you, Michael, for your information and your clarity on this. For everyone joining us, a recording of the session has been made. We'll send it out and share it. So if you missed any part of it or you want to go back, you can most certainly do so. Again, for those of you who are joining us who are not Landlord BC members, we do have a promotion running until the end of the month for $50 off membership by using the coupon code June26. Thank you and have a lovely rest of your evening.
Thank you.